So wanted to first off say good afternoon and welcome everybody to our second monthly Wealthy Wednesday webinar. We had some killer feedback last time, a lot of interest, a lot of questions that were asked post-webinar. For today, I think what we're going to do is I'll invite everybody to ask any questions along the way through the chat function, and I'll enable everyone's microphone at the end of the call and we'll have some Q&A. We want to make sure that we stay on time this time. Last time, I think we were about 15 or 20 minutes over, which was great because people were engaged. But I want to respect everyone's time. So we'll get things kicked off here. I know we'll have some people continuing to join as we continue on. So last month, topic of conversation was on estate planning, where we touched on probate and some strategies to avoid probate in general with some of the wealth solutions that we can get you access to through some of our insurance providers. Today, we're going to take it one step further into the estate planning conversation. I'm going to kick things off with just touching on, again, high level, what actually is probate. I know many people on the call here have likely at least heard of probates or potentially even had to deal with the process if you've been named as an executor of somebody's estate, potentially a parent. Reasons why you should have a will, and when does a trust make sense? I often get people ask me, who are trying to reduce their tax bill, should I be placing some assets into trusts? How can I reduce my taxes? When do trusts actually make sense? So we're going to leaning into this, talking particularly more about a testamentary trust, which comes into effect as piece of your will. So we're going to, I'll start it off by touching on it high level, and then I'll leave it to Arthur to do a bit of a deeper dive. And then again, we'll leave our Q&A to the end. But again, if you do have any burning questions or anything that pops into your mind as we continue through the slide deck, then feel free to enter it in the chat and I'll ask where it makes sense. Okay, so jumping right into it, first of all, what is probate? So again, many of you have likely heard of it. Maybe you've dealt with it. Maybe you haven't heard of it. So probate, the definition is the legal approval process to confirm, first of all, if your will is actually valid and if it's the last will. And secondly, that the individual you've named as your executor has the actual authority to act in the capacity to carry out the terms that you've identified in your will. So if you happen to pass away without having a will at death, that's known as dying intestate. A court's process to distribute your assets will become more complicated if that is the case. What I want to highlight here, just before I continue on, if you get nothing from this presentation, what I hope that you get is a little bit of motivation to just take action. If you haven't updated your will or if you don't have a will, we hope that when you come away from the presentation today that you contact both me and Arthur to make sure that you have something in place. So we'll give you some key reasons why on the coming slides that this is extremely important. And it's a simple process that should be incorporated as part of every single person's financial plan. It doesn't matter if you're just starting a family, you're young, if you're older, thinking about retirement, or what your next steps are to pass your wealth on to the next generation. A will is important for every single individual to have. Okay, so just briefly, how does the probate process actually work? We don't need to go too much into detail on the key steps, but what I want you to understand is that it takes a long time, and we want to help you avoid probate at all costs because, when going through the probate process, it is never fun. It's not an enjoyable thing to go through. And, when we went through, the lockdowns during COVID, we saw that in some cases, you're looking at 2 years plus to even, get into the court system. And we heard a number of horror stories rather, of clients who just simply were not able to get things done. And, if you're looking at a simple estate, the average is about 6 months. For a standard estate, you're looking at 9 to 12 months. For more complex estates, if you have multiple businesses, multiple assets, properties, you could be looking at 12 to 24 months or even longer. I give the example all the time of my favorite artist of all time, Jimi Hendrix. He died in 1970. He's a member of the 27 Club, died at age 27. He died intestate, so he didn't have a will at death. He probably thought he's young, he doesn't need a will, didn't have a family. Here we are in 2025 and his estate is still not settled. So that's an extreme, obviously, celebrity example, but it still very much highlights the importance of why you should have a will. You don't want to leave this to your family to have to go through those headaches. It's not fair to them. Nobody wants to go through it. So why not just, of course it costs money to set up a legal will. And we always suggest that you do this through a competent lawyer or law firm. But at the end of the day, spend the money, get it done right, and set your family up for success. Okay. So key reasons why you should have a will. So the first and foremost, choose your executor. If you want to have somebody that you trust carry out your wishes, and ideally it would be somebody that you trust, you need to name an executor. And the only way you can do that is through your will. If you don't have a will and if you don't have an executor, it's going to be very difficult to verify what your intentions actually were before passing away. Okay? Dying without a will leads to inflexible distribution. So we're living in a world currently where the reality is divorce happens, right? There's a number of blended families out there. It's pretty common these days. And you don't want to leave the courts to decide who's going to get what, right? In some scenarios, you may decide, you've had a fight with somebody in the family and you want somebody else to receive, X percentage more than the other. You may want to identify that through your will, right? And again, you want to choose somebody that you trust as your executor. Utilizing trusts, right? So we're going to talk about the testamentary trust, which comes into place effectively, if you have a will, and how that can benefit you in a number of ways. And lastly, and most importantly, you want to avoid, family disputes. You want to avoid having to go through the court system because that may, the end result may not be what your initial intention was in terms of who is actually going to be inheriting your assets. Okay. So we have the testamentary trust. So a testamentary trust is a trust that's created through a will and comes into effect only after the person dies. Okay, so I'm not going to go too much into detail on how to set this up, what it is. What I'm going to talk about is why people actually put this into place. Okay, so I have 5 key reasons why this could make sense for you. The first one is if you want to protect your minor. So there's a number of scenarios where this could make sense. Most people would not want to leave if you're expecting a multi-million-dollar, estate value. You may not want your 10-year-old to be inheriting multiple millions of dollars. Right? You may want to add some additional protection in there, and you can do that through a trust. Another option is you can provide lifetime income. So we all, I think, have that one family member who never matured or never grew up and likely could never be trusted with a large sum of money at once. You can set up lifetime income for them because you may still want them to inherit money, but if you're nervous that they might not spend it in the right way or they might not use it in the right way, you can set up a lifetime inheritance for them in the form of monthly or annual income. Okay. Preserving wealth from potential creditors or divorce. That's extremely important, especially in today's day and age. The divorce rate is 50%. We hope that everybody stays married forever, but the reality is the reality and the data is the data, right? So we suggest that you have those tough conversations with your spouse, and you may want to consider that. And if you have an ex-spouse, you may want to confirm what your intentions are and how things are set up, because we've seen, many scenarios where wills are not updated, beneficiaries are not updated. And I dealt with this earlier this year. An ex-spouse ended up receiving multiple millions of dollars just because a beneficiary was not updated. And if it's not up to date and the person has passed away, there's nothing that can be done, right? You need to plan in advance. It is one of those things that it's a tough conversation to have. It's uncomfortable, but it's something that's extremely important. Okay, there are some additional tax planning opportunities. If you set up a trust of any kind, you can look at some income splitting opportunities, ability to control and time the actual distributions of who receives what and when, some tax deferral strategies, etc. And then ultimately, the main reason why most people would look at setting up a trust, especially because it is very expensive to do, you're looking at control. Right? So if you have individuals who you plan on listing as beneficiaries or who are listed as beneficiaries that, again, you don't necessarily trust with a large sum of money or assets, you might want to have that control, and you can do that effectively through a trust. Okay? So I went through that kind of quick and dirty, super high level. I'm going to leave it to the expert, the lawyer, who we refer a lot of business to, Mr. Arthur Begg. He represents Millar's Law. I think it's one of the best law firms in the city, if not more widespread than that. So Arthur is going to go through at a deeper level kind of how wills, powers of attorneys, and trusts can help you protect your legacy. Arthur has a number of years of experience in the industry as a lawyer with his legal background. I believe Arthur newer to Millar Law, but many years of experience under his belt. So Arthur does more than just estates and wills. He also does real estate and corporate law. Very well-established individual and knows what he's doing. So Arthur, without further ado, I'll pass it over to you.
Thank you for the introduction, Bronson. Can you guys hear me?
Loud and clear.
Loud and clear, wonderful. And I'm going to take control. I think should be good now. It's working.
Perfect.
All right. Good afternoon, everyone. I got the best introduction in the world. I've been at this for about 11 years, but we'll keep that to the side for a second. My name's Arthur. I'm from Millar's Lawyers, and I just want to start by saying I really do appreciate that you're here, because I know this is the lunch crowd. That's that golden time where your stomach says eat, but your brain says let's talk about estate law. Now, thank you, though, for showing up. Alert, I know you're curious, caffeinated, ready to talk about something that honestly most people avoid. Now, the truth is, when we're talking about wills, the conversation is not about dying. It's a conversation about living with control. It's about making sure your voice still carries on even when you're not in the room. Because if you don't plan your legacy, someone else will. And I have seen what happens when someone else takes over. Before we jump into everything, though, because November is Make a Will Month in Ontario, Millar's is offering 25% off our regular rates. So if you'd like to set up a consult, remote or in person, leave your email address in the chat and we'll follow up after the webinar. Right, let's start with what an estate plan actually is. At its core, it's not about paperwork. It's about peace of mind. Not the kind that comes from a spa day. It's the kind that comes from knowing your affairs are organized, your family's protected, and no one's going to have to figure out your life from a shoebox of papers. When we talk about estate planning, we're talking about control, legal control over how your story ends and how your legacy continues. It's about making sure that your wishes are carried out your way, not by default through the Ontario's.
Arthur, sorry to cut you off. I don't know that your slides are moving. If you're supposed to be away from your intro slide. There we go. Perfect.
We should
it's moving now.
All right. So why in estate plan matters? You're absolutely right. Okay. So we hit that first point, not paperwork, but jumping back into it. So an estate plan is about making sure your wishes are carried out your way, not by default through Ontario's Succession Law Reform Act. Because here is the truth. If you pass away without a will, what we call dying intestate, the law steps in. And that law was written decades ago to be fair on paper, but not to be fair personally. It doesn't care who you trusted, who sacrificed for you. It doesn't care who you haven't spoken to since Christmas of 2007. And it doesn't care who is just waiting for your condo keys. In Ontario, the Succession Law Reform Act says, and it's strict about this, it says the estate is divided between your spouse and your children according to a fixed formula if you have a spouse and kids. There's no flexibility, no room for nuance, and definitely no line that says my oldest kid gets the dog because they actually walk it. That's not there. The law just does not work like that. And when that happens, your family ends up in the system. The courts get involved. Lawyers like me get involved at the worst possible time, when emotions are high, accounts are frozen, property can't be sold, and what started as sadness will spiral into conflict. I'll always tell my clients, this is not about death, it's about dignity. You're deciding ahead of time what happens to everything you've built and who carries your voice forward when you can't. Think about it this way. If you don't tell people where your keys are, they'll find them eventually, but they might tear the entire house apart in the process. That's what happens when there's no plan. People will figure it out, but it's going to be messy, emotional, and expensive. And yeah, there's going to be real costs. Court applications for probate, called a certificate of appointment of estate trustee without a will, and that kind of an application adds months to delay. Executor disputes can trigger motions under the rules of civil procedure. Even a small estate can burn through thousands in legal fees, all because someone thought, we'll deal with it later. I once had a family come to me, 3 siblings, great people. After their mother passed away without a will, they needed my help. She'd been organized, careful, thoughtful, the kind of person that kept everything in a shoebox to make sure everything was prepared. The one thing she never got around to was signing a will. Now, this family, they weren't fighting about money. They were fighting about meaning. They were fighting about who kept the house, who got the photo albums, who decides how to honor her at the funeral. Now, this family, they loved their mother. They loved each other, but they could not agree on what she would have wanted. That silence lasted longer than the estate case, and it was heartbreaking because 1 hour of planning could have prevented all of it. That's what a proper estate plan does. It brings clarity to grief. It turns chaos into order. It makes sure your family can focus on healing and not hearings. It's not about legal documents. It's about kindness, structure, and love, all wrapped in law. And that's what real peace of mind looks like. That's why an estate plan matters. And what happens if you don't plan? We dug into this a little bit. Now, talk about families who say it's okay. They'll say, we'll handle it ourselves. That phrase, it should come with a legal warning label. Because the truth is, when you die without a will in Ontario, the law steps in and it takes over. I can't say that enough because it decides who gets what, how much, and in what order, all based on a set of formulas written in the 70s. So unless you've always dreamed of your life being summarized by a spreadsheet, this might not be your ideal ending. Now, I hinted at this before. The law isn't cruel. It's just indifferent. It's built to be fair on paper, not personal. And this is where people get blindsided. When you die without a will, your bank accounts could get frozen. Even if your spouse is joint on one, it doesn't always mean automatic access. You got to make sure your bank knows what your intentions are upon passing. A will helps there. Not all joint accounts have a right of survivorship. Without a will, your family might not be able to sell property, close accounts.
Arthur, let me pause there for 1 second.
Yeah.
Okay. So let's talk about the difference between joint with rights of survivorship versus tenants in common. Okay. Because oftentimes, first of all, the banks will just offer you the easiest solution. I pick on the banks. I shouldn't, but I do because it frustrates me.
It's super easy to pick
on. A lot
on.
of times when people are talking about how can I avoid probate, the bank will suggest, well, just have all of your accounts joint with your kids. That is not always the best solution. First of all, I've seen this. Sometimes it's set up as joint tenants in common, which does not avoid probate, because what that means, the distinction is rights of survivorship means when one joint owner passes away, they're removed from the account and their surviving owners continue on with the ownership of the account. When anything is joint tenants in common, that means one individual, if they pass away, let's say they own 50% of the account, they're going to reference the will to see who is the beneficiary of that 50% of the account now that this person has passed away. It does not continue on. The assets could still be frozen, as Arthur is alluding to, right? And that's extremely important to understand, because I ask people, when they tell me, okay, we have, should be fine, we should avoid probate. The bank told us just have joint ownership. Well, what kind of joint ownership is it? We encourage you to verify that. That's extremely important. Sorry, I had to butt in there.
No, you're absolutely right. With title, it's super easy. It's got your deed has it clearly right on there that you own the property with jointly, and you're getting that with a right of survivorship. If you're not getting that, if it's tenancy in common, it's right there with banks. They don't always make it that easy, right? You've got to make your intentions super clear. And I appreciate the thoughts there. But yeah, without that intention being cleared up, without a will, your family's not going to be able to sell property. They're not going to be able to close accounts, pay the funeral bill, without applying for the certificate of appointment for a state trustee without a will. That used to be called probate. I still call it probate. And the probate process, it's not quick, it's not cheap. With a will, the process can take 4 to 6 months to get the paperwork through the system. And it always depends on the court's backlog at the time. It could be longer, could be shorter. Without a will, though, the process can be stuck in limbo until the beneficiaries come to an agreement on who the executor is. Meanwhile, property taxes will still keep coming. Insurance renewals will still keep landing. Mortgage payments will still be due. And your loved ones will be sitting there saying, we want to just pay the hydro bill. Why is the court involved? And why is the court involved? Let's do everything that we can while we can. I had one file a few years ago. Lovely married couple, married 40 years, 3 kids, no will. Husband passed away suddenly. And the widow thought, understandably, that everything would automatically be hers. She came into my office, said, Arthur, it's fine. I don't need your help. We're married. The house is mine. I had to very kindly explain to her that under the Succession Law Reform Act, her spouse, she and the children will all share the estate according to a formula. She'll get what's called the preferential share, currently $350,000, and the rest is divided between her and the kids. That's because her husband owned the property in his name only, not jointly with her. Now, she looked at me and said, are you telling me that I have to ask my kids for money from my own house because of the way the law works? I said, yeah, you've got to, but you should ask nicely. Right? That's how the law works. It's not malicious. It's just mechanical. And when there's no plan, it turns grief into process.
I'm going to bring up one more example here on that topic.
Yeah. Okay. Absolutely.
There was a case that happened in, I believe it was Nova Scotia a few years back. And there was a bank manager. I believe the bank was it doesn't matter, the bank, CIBC, but it doesn't matter. The bank manager was there for about 20, 25 years. When he first started his career, he was around, say 20 years old, fresh out of university. And so he listed his mother as the beneficiary of his RSP account. Okay. He later got married, had kids, et cetera, passed away at an early age due to a heart attack. Never updated his beneficiaries on file. Okay. So what do you think happened? The mother got the money from the RSP. So his wife, happily married, no issues. His intention would have been for his wife to carry on with his assets, right? Including his RSP. Because he didn't list his wife as beneficiary or spouse on file, the mother received a check for the RSP money. The wife had to go to the mother and say, can I please have this money so that I can afford to live? And the mother has the right to say no. And she did say no. She was in her later years of life, and she said, well, if, Sonny wanted me to have the money, that must have been his intention. That is the importance of making sure that your documents are up to date.
Yeah. You're absolutely right, Bronson. And that's the kind of heartbreak Bronson and I see over and over, week to week, because all that time, energy, and money, it all could have been avoided with just one clear and simple plan. It's why estate planning isn't about being rich. It really isn't. It's about being responsible. It's how you protect your family from a system that wasn't designed to know your family the way you do. No, let's not let the law write your family story. Let's dig into this. Wills. A will is your voice after death. It is your final act of clarity. It's your chance to say, this is how I want things to be handled, in your own words. It tells the world who you trust to carry your legacy, your executor. It explains who is going to manage your estate, who's going to look after your children, and who's going to receive what you've built. But it's more than just a list of names and numbers. It's a reflection of your values, what mattered most to you. I had one client left his entire wine collection to his best friend, included a note that said, don't drink it all at once. That is a man who planned with humor and purpose. Now, jokes aside, I know you're all laughing. Every good will does that. It carries personality. You can feel the person behind the piece of paper. Now, legally speaking, you really should have more than a couple of jokes in your will. A will is one of the most powerful documents you'll ever sign. It does three critical things. It names your estate trustee. This is the person that steps into your legal shoes after your death. It directs how your assets are divided, and it ensures your estate passes efficiently, avoiding court battles and confusion. But here is the part that people underestimate, most people. The formalities matter. Now, until recently, Ontario had what we called a strict compliance system when it comes to wills. If your will wasn't signed in writing by you, witnessed by two people at the same time, and signed by them in your presence, it wasn't valid, no exceptions. And then came 2022. Something important changed. Ontario introduced a new concept called substantial compliance under the Succession Law Reform Act. That change allowed the Superior Court to validate a will that doesn't strictly meet the formal rules if the court isn't satisfied that it's authentic and clearly reflects your final intentions. In other words, the court can now say, okay, this is not perfect, but it's clearly real, which, let's be honest, that's a phrase most lawyers don't get to say. Now, let's jump back into it. Now, this change, it was a big deal. Before 2022, if you missed a witness signature, forgot a page, or left your will half handwritten or half typed, it was invalid, full stop. Now, with substantial compliance, the court can fix certain technical errors, but this is crucial. This is not a free-for-all. This doesn't mean you walk around thinking that the court will fix your mistakes. They won't. The will must still be authentic, and it must show what we call a fixed and final intention. That means it'll need to clearly show what you wanted to happen when you die, not just notes and drafts or ideas. The court has a two-part test for this. Is the document authentic? Does it show a final intention about how to distribute the estate? If both of the answers are yes, the court might be able to validate it. Let me give you a few examples. In the Cruz case, the deceased wrote his own will, sealed it in an envelope, and gave it to a friend to get witnessed. He died before that happened. No witnesses. Under the old law, it would have been invalid. But the court, in this case, said, no, this clearly reflects his testamentary intent. And it's valid under Section 21.1 of the Succession Law Reform Act. In another case, Boy Scout, there was a missing witness signature, still validated. Kroskov, the will was part handwritten, part fill in the blank. Court still found it, met the test. It's clear. Ontario courts are looking for intention, not perfection. But, this is important, do not rely on the courts to save you. Substantial compliance is a safety net, not a substitute for doing it right. Because every time you need to get a judge to rule on your will, you're adding months of delay and thousands of dollars in cost. Let's be clear. When you pass away, your children's feelings that the will counts is not what makes the will count. The court will need strong evidence of something that reflects your final deliberate intention, and your estate's lawyers will take a lot of money that could have just went to your children instead of going towards figuring out what your final intentions were. So get your final intentions set out in a will that's signed, done properly through a lawyer's office. Make sure there's no room for error. Now, properly executing your will is the safest, smartest, kindest thing you can do for your family. Court applications should not be part of anyone's estate plan. Now, let's talk about something people love to ask me. What about handwritten wills? On the back of a Kleenex, on the back of a utility bill. Yeah, they're legal in Ontario. They're called holograph wills. They're valid if they're entirely in your handwriting and signed by you. There's other details, but essentially it means no witnesses are needed. These wills, holograph wills, they were born from emergency situations. Miners trapped underground, soldiers at war, people writing final instructions when lawyers were not available. So yeah, they're legal, but they were not designed for comfortable suburban living. They're still used. I've seen them written, like I said, on notepads, recipe cards, utility bills. And if they meet the 3 tests, they can be valid. You actually wrote it. You had capacity, meaning you knew what you were doing. And it expresses a clear intention to distribute your estate. But holograph wills can be dangerous and they can complicate things. What you intended to be a simple will complicate things at court with additional delays to prove the will, and even more complexities if there's confusion about intent or capacity. In most cases, it means delay, cost, and stress. It's not the simple solution people think it is. It can rob your estate. The law's allowance of holograph wills and the recent introduction of substantial compliance, it makes our system more humane. It allows for compassion where technical errors can cause heartbreak. It's an important part of the law, and I'm glad it's there. But make no mistake, properly drafting and executing your will is the gold standard, and it's the only way to go. It's the difference between your family walking calmly through a plan and stumbling through a process. You're essentially signing a love letter with structure. That's what peace looks like. Now, part 2, powers of attorney. We talked about your voice after your passing. Now we're going to talk about your voice during your life. Here's something that surprises a lot of people. Your powers of attorney might actually be more important than your will, because your will speaks after you're gone, but your powers of attorney, they speak while you're still here, when you can't. These are the documents that give someone the legal authority to act on your behalf if you become incapable. There's 2 types. They're both essential. There's one for property, so someone can manage your money, pay your bills, handle the mortgage, even deal with the CRA if you need to. And then there's another one for personal care, so someone can make health and life decisions when you can't. They're basically the legal version of picking your emergency contact, but with way higher stakes and much less chance that your cousin's going to forget to pick up the phone. Now, choosing who picks up the phone, that's important. Who gets that power? It's a whole family exercise in trust. You're not just picking someone organized, you're picking someone you trust with your bank account and your body. It's like saying, all right, who's the responsible one here at the Thanksgiving table? And suddenly, everyone looks at the same sibling. These documents, jokes aside, these documents are about protecting your dignity and not just your assets. It sets out who can act for you, when they can act for you, and under what circumstances. A power of attorney for property gives your chosen person, your attorney, the ability to manage your financial life. That can mean paying bills, handling investments, selling property, or even signing legal documents for you. The key point, you can make it effective now, immediately, or you can make it effective if you're found incapable. Most lawyers, myself included, recommend the latter, because you don't want someone managing your money while you're still able to just yell, "I'm fine," from the couch. No, when you don't need it, you don't need it. Don't risk it if you don't need it. The second one, power of attorney for personal care, that might be more important. It lets someone decide on your health, housing, and end-of-life care if you can't communicate. That's the document doctors look for when you're in the hospital and can't speak for yourself. It's what decides whether someone you love and trust has the right to say, yep, that's what they wanted. And if you don't have one, your family can't just step in. They might have to go to court and apply to be your guardian of property or guardian of the person. The process is long, invasive, and emotionally brutal. I've seen children have to testify about parents' mental capacity, and it's not a memory anyone wants. With a properly drafted power of attorney, you avoid all of that. You choose who you trust while you're healthy, confident, and in control. Now,
Arthur, can you speak on how long that process would take if, someone experiences an example where, there's a downturn in somebody's, medical condition and they don't have a POA in place? How long does it take to go through the court process to prove that you should, let's say they have a spouse or a child, how long would that process actually take?
It really depends on the backlog, right? It could take a couple months. right? It's not a process that I think anyone should go through unless they really need to, right? And while you're able to make the decision, while you're able to sort out your personal finances, this is one of those decisions you should be making as early on as possible. Yeah.
I'll just share a quick personal story here. So
Sure.
my father-in-law got diagnosed with a rapid form of dementia over a year ago. And, his life expectancy was anywhere from 3 months to 12 months. And prior to his diagnosis, we noticed, certain cognitive abilities starting to decline. So I asked my mother-in-law, do you have a power of attorney? They said, I think so. We have a will. They are not the same, right? A power of attorney is a separate document for both property and personal care from your will. So verify, if you do have a will, that you also have a power of attorney, and when that power of attorney can take effect. That's extremely important. Fortunately, we were able to get the power of attorney in place, but again, he passed away 6 months after the diagnosis. So if the process takes multiple months, what would have happened? That's a scenario you don't even want to imagine.
No, you could have been just paused for a lot longer than you needed, right?
Absolutely.
And you could have lost money, you could have lost patience, time, family. Yeah. Now, you dug into this a tiny little bit. There's a legal nuance here. The problems start, there's other ways for problems to start. There's always a way for problems to start, right? Let's say you do have a power of attorney. Let's say you've granted the authority to someone that you trust. The authority that you're granting, it's enormous. This person can sell your home, access your bank accounts, and make binding decisions on your behalf. So capacity and trust are everything. To sign a power of attorney for property, you've got to have the capacity to understand your assets. And to sign a personal care power of attorney, you need to understand that the person you name will make those health decisions for you. Now, we need to get to you need to make these decisions before there's before that even becomes a question. How much capacity do you have? Which power of attorney can we sign? Which one can we not sign? Right? But also, who are you trusting? Because just setting out a power of attorney and giving it to anyone you can name is not something that you should do either. Again, this person with a power of attorney for property, they'll be able to sell your home, access your bank accounts. These are big decisions, right? And if you trust them, you've got to also figure out when you trust them. Do you trust them now, or do you trust them when you're incapable? It's a larger conversation we have at the firm when you come in for an appointment, but we'll keep going for now. The hard truth is, if you don't set these documents out, once you lose capacity, it's often too late. So when I say, and when Bronson says the powers of attorney might matter more than your will, it's because they protect you while you're still here. With a will, you control your legacy. With a power of attorney, you control your life. That is real power. You're not going to be around for the decisions set out in the will. That's to take care of your family. But with a power of attorney, you're taking care of yourself. All right. Now, trusts. This is a bit more control beyond that. It's one of the most powerful tools in estate planning. It lets you shape your legacy long after you're gone, not just the next generation. You can use a trust to provide for your children, protect a loved one with special needs, manage how and when your assets are used, or transfer wealth without delay or the publicity of probate, right? One of my favorite ways to describe the process is this. A trust is how you say, I love you, but I also know you. And if you've ever met your family, you know exactly why that's necessary. Yeah. There's two broad categories of trust in Ontario. Inter vivos trusts, that these are trusts that are created while you're alive, and testamentary trusts. Bronson went into this. These are trusts that take effect through your will after you pass. Both of them can hold assets like real estate, investments, or business shares, but the key difference is timing and control. An inter vivos trust is active right now. It's like giving your money a manager while you're still the CEO. Now, with inter vivos trusts, there's a few common types. There's family trusts, there's spousal trusts, and there's the alter ego for clients over 65. The last one, the alter ego, it's one of my favorites. It's basically saying I want everything to work like an estate without having to die first. The key benefit is that an inter vivos trust separates legal ownership from beneficial ownership. That means the trustee holds title to the property, but beneficiaries enjoy the benefit. Now, that separation can help protect against lawsuits, business creditors, even family disputes. And since the trust owns the assets, not you, those assets often don't need to go through probate, which could save your estate both time and money. But with that power, it comes responsibility. Trustees have what's called a fiduciary duty, the highest standard of care in law. They must act in good faith. They must avoid conflicts and make decisions that benefit the beneficiaries and not themselves. Now, this isn't just being responsible, it's being legally accountable. Testamentary trusts. I won't go too far into the intro part here because Bronson, you set it out pretty well. But real quickly, they come into play through your will. They activate upon your death, and they can be used to hold funds for minor children and grandchildren until a certain age, create what's called a Henson Trust for a beneficiary with a disability so that we can preserve their ODSP benefits. We can use it to manage assets for blended families, second marriages, or complex estates. A testamentary trust can give you control without micromanagement. You can say, my child gets access to income now, but not the capital until they're ready. It's structure, not restriction. Think of it this way. Normally a simple will distribute your assets once, but with a testamentary trust in your will, you can distribute your wisdom forever, or 21 years. Now, I had a client once, a retired doctor, said, I don't want my estate to make my kids rich. I want it to make them thoughtful. So we built in a trust, paid out in stages, enough to live comfortably, but not rob the estate all at once. So whether it's a family trust to protect your assets today, testamentary trust to protect your values tomorrow, message is the same. A trust is about care. It is a legal form of foresight. And if a will is your voice after death, the trust is your echo. All right. The tale of two families. We've got one with a planned estate and one with no plan whatsoever. Two families, same city, same neighborhood, same level of success. Both had worked hard, built comfortable lives, and owned homes they were proud of. I'm taking a look at the clock. We're not going to have too much time for questions, so I might just skip through some of what I was going to say in my notes here and allow people to ask some questions. But just putting it all together, we've talked about powers of attorney, wills, trusts. It all connects. One's about death. One's about how you want things managed after death. One's about how you want things managed while you're alive. And trusts, they're about how you want things managed long after you're gone. It all works together.
Amazing. Thanks, Arthur. Why don't we jump to your second last slide just before your the one with your logo on it.
Yeah, so I'll stick to that one for now because we've only got 10 minutes. I'll let you guys stick to it with any questions that you guys have.
Yeah, so I think that was great, Arthur. Thanks so much for taking us through that. What we hope you get out of today is really just a reminder, you know, a lot of this information, I know many people on the call today are aware, should be done. It's a reminder to double check that it is done, and if not, to take some action. There may be some people who don't have some of these features in place. And if you're unsure, feel free to reach out, right? You know, I always say a conversation is free. I don't bill by the hour, right? So if you're nervous to reach out to Arthur first, most people tend to be like, well, I think I should speak with a lawyer, but I don't know if you know, I should be spending the money. Well, I can give you advice on that too, right? If it makes sense to speak with Arthur, I'll tell you so. And if not, if it's something that I might be able to help you with directly, because we do have solutions that can help with some of this, specifically with avoiding probate, then we can have that conversation, right? So, you know, what we're hoping to offer as a firm is basically a one-stop shop, right? We have other, you know, partners that we work with. We don't have an in-house lawyer, but we have, you know, people like Arthur who we can refer you to. So when the situation makes sense for you, we will give Arthur a call and we'll connect you to say, hey, you know, this is the situation. Arthur, can you help with this? Right? So whatever concern you have, whatever questions you have, you know, always filter through us first, and we can always delegate accordingly. But we'll leave it open to questions in the next 10 minutes here. If anybody has any questions that they'd like to ask specifically to the webinar or just general scenarios as well, we're happy to take those questions at this time.
Sometimes it's hard to talk about personal things right in front of everyone, especially if it's a webinar. These issues can be personal, right? So if you want to keep things vague, generic, you can pump it in the chat. Is there a way to make these make the chat anonymous, or not so much?
I don't think so. However, we can always take it offline too. If you have personal scenarios that you'd like to discuss on a one-on-one basis, we can definitely tackle that together. So feel free to reach out, and we can handle that conversation. You know, I think the time period is like 30 seconds of silence or something before somebody gets nervous and says, okay, I'll ask a question.
Let's try it out.
So let's see. Anybody? All right, cool. So hopefully we did a great job on the webinar and there are no questions whatsoever. But again, really appreciate everybody jumping on the call today. Again, we are doing this monthly. Thanks, Brian. Thanks for attending. We are doing this on a monthly basis. So every second Wednesday of the month, same time, same place, 12 o'clock. You'll always receive my emails and the invite if you're on my newsletter list. But again, happy to take any conversations offline. Feel free to reach out if you have any questions, and I will see you next month.
Take care, everyone. Thanks for your time.
Thanks, Arthur. Appreciate it. Take care, everyone.